Yes.
Lords, we've reached my final point, which relates to a modification that the appellants made to their infringing system. It moved from what is called, in the context of this case, the mPower system to the modified mPower system. This took place in 2014 in the context of an infringement action in Germany, and the modification was the removal of the timing feature. So what that means in substance is their system moved from a Claim 2 system to a Claim 1 system. And this point relates to the obviousness of the Claim 2 system. Now, notwithstanding, we accepted that the products without the timing feature did not in fact infringe Claim 2, we maintained an allegation that there were still ongoing acts of infringement in the form of offers for sale. And broadly speaking, the complaint was, you haven't told your customers that you've made this change. You told them about the timing feature before, you haven't told them you've taken it away, so they're still buying a product with a timing feature, which means that you're offering a product with a timing feature. And we need to see how this all played out in the pleading. So if you could please take the core bundle.
Can you just identify for me, what, this is going to which issue?
So the issue this goes to is the obviousness of Claim 2.
Right.
And let me explain how the point works.
Yeah.
Their claim on the obviousness of Claim 2 is the skilled person would have incorporated a timing feature. It was obvious to do that because it helps with safety. And that clashes with their pleaded position before this court. And I rely on that clash to gainsay their obviousness case.
So this, again, is not the respondent's notice point?
It is a respondent's notice point. The judge...
Is this your paragraph 8?
This is paragraph 8, my lord,
Yeah,
yes,
right.
exactly that.
Okay, no, I understand. Thank you.
So if I could pick it up in pleadings, in the core bundle behind tab 18, please. Page 186E. And towards the bottom, you'll see paragraph 8b. That's where we say the claimant will say that the defendant's dealings in relation to the modified mPower system.
Sorry, wait a minute.
I'm sorry.
Okay, paragraph 8.
8b, which is towards the
yes,
bottom.
I see. Okay.
So we say dealings in the modified system fall within the scope of Claim 2 as follows. Starts that they've promulgated the safety features of the unmodified systems. And then over the page, in particular, we rely on their promotion of the timing feature. And you see that in the quote. This is from one of their promotional documents. As part of system safety, in order to activate ACOU, that's their outlet, ACOU power, the points of the AC power plug must be inserted within 300 milliseconds of one another. So that's part of their marketing pitch. And then towards the bottom, we make good the point by asserting in 8b6 and 8b7 that having put this pitch out there, they haven't then corrected the position. We say they did not inform purchasers, end purchasers, or potential purchasers, or end purchasers, that the modification had a material effect on the safety features of the mPower systems. So, broadly speaking, we say having told people they've got this wonderful timing feature, they then fell to them to say, we've removed it. Because in the market, we say that may have had an effect. They have, we say, made their product less safe, and they should have told their customers. And the way the point works in this case is given force by the response to that pleading, which rather took us by surprise. You'll see the response behind tab 15. Page 165, Roman 6, towards the middle of the page. It is denied that the modification had a material effect on the safety features of the mPOWER systems. That's the proposition that we are concerned with on this point. But just while we're here, you'll see also the sentence that I referred you to in relation to mindset. The modified mPOWER system remains authorized by the FAA. It is denied that the modification had a material effect on the safety features of the mPOWER systems. Note please the plural, safety features. Not the overall safety of the system, but any effect on the safety features. Now, we say that as a matter of language and logic, removal of the timing feature can only be said to have had no material effect on the safety features of the mPOWER systems if it was not itself a safety feature. If you go from 5 safety features to 4, you have had an effect on the safety features. The appellant's response to this is to say what they mean is that the overall safety of the system has not changed. Now, that's not what the pleading says, but I'll engage with that argument anyway, because they can't make good that point either. The basis upon which they advance that argument is, we've got another safety feature. They say, we have a ground force interrupt. Because they've got another feature, they say, it doesn't matter that we've got rid of timing. And there are 2 reasons that that argument must fail. The first is that a duplicative safety feature is still a valuable safety feature. Commercial aeroplanes have to have a backup for every critical control system, even if the backup is functionally identical. That's because it's valuable in and of itself to have system B if system A goes wrong. And think on a more domestic level, you'll be familiar with the trip switches in a consumer unit at home, which is providing duplicative protection, given that you've got a 13 amp fuse in your plug. It is valuable in terms of safety to have more than one system. The second answer is that it's not in any event duplicative, because the 2 systems work in a different way, and in an importantly different way. A ground force interrupt works by sensing a current surge. So if you attach your fingers to the live and the neutral plugs of a mains AC outlet, which is protected with a ground force interrupt, there will be a hell of a current surge that is then cut off very quickly by the ground force interrupt. It senses that the current demand is higher than it would expect and responds to that surge by cutting it off. So it does reduce the danger of electrocution, but it has to be triggered by an initial surge in power, so it's not a perfect system. And so if we consider our child with the pair of knitting needles on the aeroplane, if that child sequentially introduces the knitting needles into the live and neutral pins of the socket, it will receive a mains voltage electric shock until the ground force interrupt cuts it out. Now, I don't know whether that could be fatal or not, but it's not going to be enjoyable. Whereas with the timing circuit, if you sequentially introduce the knitting needles, you don't get any shock at all. So it's not perfectly duplicative. There is additional and different safety provided by the timing circuit. Now, the only way that this pleading, the pleading of the appellant's defence, can be accurate is if the timing feature is irrelevant to safety. And that is the basis upon which we say you should approach the appellant's obviousness case. They have seen fit to say, in terms to this court, because it suits them in relation to infringement, the timing feature is irrelevant to safety. And you should not respond to that by accepting their contrary submissions on obviousness, that that's why the skilled person would think to introduce it.
Mr. Cuddigan, if the timing feature is irrelevant to safety, why is it invented?
So, my lord, it's not my case. It was never my case that the timing feature was irrelevant to safety.
You say it is relevant to safety.
My case is that it's relevant to safety. What I'm pointing out is an inconsistency in my learned friend's case. He can't have it both ways. He's seeking to have it both ways. There is a clear pleading on behalf of all these appellants, and I can show you it in the Panasonic document as well if you want to see it, that it's irrelevant to safety. And it is they who are asking you to say, it's such an obvious safety feature that the skilled person would just pop it in there. That's the inconsistency I rely upon. There's no inconsistency in my case because I accept it's a safety feature. My lords, unless I can help you any further, those are our submissions.
No, thank you very much.
I will be brief, and I'll take things in the same order, certainly, as far as today is concerned, as my learned friend has. As far as the law is concerned, my learned friend showed you a little bit more of Virgin, which your lordship will certainly be familiar with. And of course, Virgin is authority for a number of propositions. But Virgin doesn't address whether or in what circumstances the skilled person would take the trouble to turn up the acknowledged prior art in relation to question of construction. That, as the authorities to which we have referred, is a question of fact and circumstance, depending on the particular issues in the case. Now, in the present case, my learned friend says, I quote him, the judge got it right. If in doubt about interpretation, go to Quintel. Now, that is precisely what the judge did not find, because the judge, amongst other things, records in paragraph 79 that he was faced with a case in which neither of the experts had given any evidence that the skilled person would take the trouble to turn up Quintel. And furthermore, certainly in the case of insertion, the judge points out correctly that there is nothing in paragraph 5 of the specification that suggests anything that is going to be gained from Quintel in relation to that issue. As far as Quintel itself is concerned, my lords, your lordships will have by now seen the document in some detail, SB1 tab 4. Could I just make two observations about it before we leave? And so if you could take SB1 tab 4, page 30 is where I wanted to start. As your lordships know, Quintel discloses two different embodiments. And looking at page 30, just above, in the middle of page 30, and I'm using page 30 as the transcript, as the bundle reference, there is a paragraph that starts generally. Contact between the plug and the socket is ensured by 2 or 3 pins, and so on. It goes on to say, consequently, where the mechanical contact is poor, there are risks of sparks and heating, which result in oxidation of the pins, and such oxidation in turn contributing to degradation of the quality of the electrical contact. And then the first object is, as is said there, refers to proper insertion, which amongst other things will reduce the unwanted resistance. Now, again, this is one of these cases where context is important, and the particular context, at least that Quintel is calling out here, the risks of sparks and the risks of oxidation occasioned by imprecise contacts between the terminals and the sockets are not said, and no one has ever said, to be of particular relevance in the context of an aeroplane cabin. Certainly as far as sparks are concerned, and I'll give you the evidence reference, it's Professor Wheeler, SB1, tab 6, page 76, paragraph 141. He explained that sparking is only a concern in specialist applications, for example, where there may be a build-up of flammable gas or underwater. And underwater then takes us to the second embodiment in Quintel, which is said specifically, page 32, the first paragraph, page 32, this invention also relates to an application relating to underwater electrical connections. So the context in which Quintel is discussing full insertion is a very different context to the one with which the patent and the issues in this case are concerned. And I would urge your lordships to take that in mind, or would bear that in mind. But continuing with the insertion point, my learned friend yesterday explained to your lordships that in this case, all the devices with which we are concerned, whether they be the patented device, infringing device, prior art device, they're all designed to mitigate well-known safety risks, and they all deploy authentication tests such that power will not be supplied to the plug until the authentication test in one form or the other has been passed. And he said the objective is to distinguish, certainly in the context of an aeroplane cabin, between genuine plugs and inquisitive children with paper clips or knitting needles. What he didn't explain to your lordships is why full insertion is the means by which that objective is achieved, distinguishing between a genuine plug and an inquisitive child. And that's an important omission. Really, one other point on insertion, and that is just to make sure that your lordships do not understand my submissions in relation to plugged in, which is one of the terms that is used in the specification in the way that it was characterised by Mr. Cudding this morning. Plugged in, as your lordships will recall, is referred to in paragraph 15 of the specification, where it's referred to as being one of the methods for detecting the plug in the sockets. It is not my submission that paragraph 15 discloses that the plug's pins only need to be inserted halfway in. My submission to your lordships is, as the judge found at paragraph 70, the patent does not specify the minimum distance that is required for that method to be achieved. And indeed, that finding was entirely consistent with the evidence that was given by Professor Wheeler, which is that that part of the specification leaves it to the skilled person to decide how big or how small to make that separation difference. And that is for your reference day 2, and I'm afraid I'm going to give you the transcript page numbers, if I may, 278 line 17 to 279 12. As far as remoteness is concerned, my Lord Justice Birss asked yesterday whether there was any, or what indications. Sorry, I think no, that comes. Sorry, I've jumped ahead. I'll come back to that point. 3 points as far as remoteness is concerned. First of all, the cross-examination of Professor Wheeler, and my learned friend took you to some of that cross-examination, and he stopped at a point that was convenient to him, but which is nevertheless important. Can we just take it again, and I'll show you the passages which are to bear in mind when considering the witness's cross-examination. So it's SB2, tab 21, bundle reference, page 446. And Mr. Cuddigan, do your lordships have that?
446.
446.
Yes.
So the internal transcript pages are 254 and 255. And Mr. Cuddigan took you down to 255, and he stopped at line 16. And I would urge your lordships to read on. So you agree with me, physically separating the supply device and the socket? Yes. Paragraph 10 states the supply device can then be arranged in a way that there's no source of danger to the passenger. Yes. So you agree with me, it's about physical separation. Well, it's about design option. The judge, so the witness is acknowledging there that there is a design option. But plainly there is. But to stop the cross-examination reference at line 16 is not fair. And since we have the transcript open, I did give you the full reference yesterday, but can I ask your lordships to make a note of the transcript reference, or the cross-examination on this topic as it extends to transcript page 259, line 16, and there you will see the discussion between Professor Wheeler and myself about the cables and the fact that the length of the cables has no effect upon their capacity to deliver an electric shock at one end, and hence it is all about physical separation. Second point on remoteness. My learned friend took you to figure 1 of the patent. And this morning he envisaged an arrangement in which the supply device, which is obviously component 16, were to be moved to position 32. And the dangers that would then be consequent upon that position, because the cables supplying the supply device, if it was in position 32, would be running all the way through the chair. And that is precisely the point which I was seeking to articulate yesterday. The patentee is not concerned about those as a source of danger, because, as we see them in figure 1, they are located on the floor, underneath the seat. If the patentee was concerned about those cables as being the particular source of danger, not only would there be a reference to them in paragraph 10, when paragraph paragraph 10 actually only refers to the cables between the supply device and the socket. The figure 1 arrangement would make no sense whatsoever. The third point on remoteness is my learned friend submitted to your lordships that there was material on which the judge was entitled to conclude that the supply device itself was a source of danger. And the evidence that he referred you to was Mr. Borowski's evidence, paragraph 177, where Mr. Borowski was explaining that one of the reasons for locating the supply device under the seat would be for the purposes of rendering it more safe. Lord, that submission that I made to the judge as to a reason for locating the supply device under the seat for the purposes of safety was one which he rejected. If you take paragraph 207 and 208, where the judge is dealing with the airing specification, he describes in 207 what the airing specification discloses. You will see in my written closing submissions to the judge at paragraph 150 a submission that the reason why those components were located under the seat was for the purposes of safety. And the judge finds in 208 that the airing specification establishes the desirability of placing the electronics box out of the way under the seat, but that is apparently for reasons of cabin design and convenience. So the judge has rejected the submission that was put to him. That safety was the reason, or one of the reasons for placing the supply device out of the way under the box, and has instead found that it is a matter simply of convenience. My lords, next uncertainty, two points just to pick up on. I referred yesterday to my learned friend's skeleton argument, in which the concept of remoteness was explained as being keeping the device away from the passenger, such that cables to the passenger's socket are only live when in use. The proposition seems to have changed a little bit. This morning he said that the purpose is that to ensure that both socket and cables are quiescent when the socket is not in use. However one puts it, and let's take it in the way that it's now put, socket and cables are quiescent when the socket is not in use. That is absolutely blind to distance. Whether the socket is close to the passenger, whether the cables are long or short, the distance between the supply device and the socket can have no effect upon whether the socket and the cables are quiescent when the socket is not in use. The other way in which it was suggested, perhaps a little more faintly this morning, was keeping the supply device out of the passenger area. What does that mean? Out of the passenger area. Again, the limitation that my learned friend seeks to read into the claim has no objectively verifiable means by which one can say yea or nay, this is a product which satisfies the characteristics of the claim. So I do maintain that the claim on the judge's construction was hopelessly uncertain. And the fact that there is one can identify a product or a number of products which satisfy the claim is not in itself an answer to insufficiency, for the reasons given by Lord Justice Floyd in Anand Kasai in a recent case. Can I just ask your Lordships, well, I'll take your Lordships to the judgment and just identify the relevant paragraphs. So it's Authorities Bundle Tab 8. Lord Justice Floyd's summary of the law starts at paragraph 21. It runs all the way through to paragraph 27. And it's paragraph 27 at the end where he says, for my part, I don't agree that the objection of uncertainty is answered simply because there is something within the claim which is clear if there is a large territory, more than a fuzzy boundary, where the claim is uncertain. Finding something that infringes is not an answer of itself to insufficiency. My Lords, Neunschwander, and this is where I jumped ahead of myself. Lord Justice Birss asked me yesterday whether there was any indication, what indications there were in Neunschwander as to the nature of the light barrier means. I think the clearest indication of what light barrier means is comes in the claims, and claim 1, so page 19. Claim 1 is an apparatus claim which includes, amongst other things, line 30, a light barrier means, and the light barrier means there is connected with said relay, and the relay is identified in the preceding 3 lines. A relay for making and breaking electric contact between said connector ends and said supply line in response to a predetermined signal. So the key proposition, my Lord, is that the light barrier means is distinct from the relay. So that was the first point on Neunschwander. 2 other short points on Neunschwander. My learned friend spoke this morning about the apparent lack of evidential basis for the separate construction of the supply device and the socket in Neunschwander. The evidential basis for that was contained in terms in Professor Borowski's evidence at paragraph 152. He refers in that paragraph to the diagram. And critically, in paragraph 152, he also refers to the text in column 6, in which the conductors are said to extend from the receptacle to the amplifier circuit. And in the next paragraph, Mr. Borowski refers to the figure 5 embodiment, and he says that the figure 5 embodiment can be used with that same circuitry. And the point my learned friend makes about my complaint in respect of figure 5, your Lordships will recall that that is one of the criticisms that I make of the judgment, is that in making his findings as to what is clearly and unambiguously disclosed, he makes no reference to figure 5. He doesn't in the relevant paragraph where he's discussing what is or is not disclosed. 147. That is the point that I was making. His analysis of what is clearly and unmistakably disclosed in Neunschwander does not include any reference to figure 5. although it has been referred to him in the submissions, as one sees in paragraph 146. So that was all I was going to say about non-standard. As far as obviousness over claim 1, the procedural complaint, so in other words, we're looking here at obviousness of claim 1 on the judge's construction. I'll give you the references to the grounds of appeal, paragraphs 7 to 14, and the skeleton argument at paragraphs 89 to 90. And your lordships will see in both those grounds and in the skeleton clear references. Well, let me show you rather than. There's no doubt about it. If your lordships take the grounds of appeal first of all, which is core bundle tab 2. Paragraph 7 of the grounds, there is an attack on the judge's findings of lack of anticipation. If you then read on from paragraph 7, paragraph 8, obviousness, failure to take into account common general knowledge findings. Look, for example, at 8(2). The skilled person will be aware of the desirability of placing an electronics box out of the way under the seat. And 2, the need to avoid liquids coming into contact with the electrical supply. And paragraph 14, had the judge not made the errors identified in 7 to 13 above, he would have found that claim 1 of the patent was anticipated, alternatively obvious over non-standard. So I do say that the grounds of appeal include a clear attack on the judgment and a clear basis for a finding of obviousness on the judge's interpretation of the motives. And as far as the skeleton is concerned, which is tab 5 of the same bundle, you will see, for example, paragraph 89, a reference to findings as common general knowledge, all of which highlighted the advantages of locating the power supply separately from the socket. Number 1, the practice of putting the power supply in-flight entertainment system in a separate electronics box. 2, the desirability of placing the electronic box out of the way under the seat. And then in paragraph 90, although this is in the context of the M-power system, the last sentence, in other words, one power supply served multiple seat units. The power supply had to be remote, brackets, in the judge's understanding, from at least some of the outlets. As far as the evidential position is concerned, Mr. Borowski's evidence, and I think it's worth taking it again just to be absolutely clear, no ambiguity about what I'm referring to. Supplementary bundle tab 1, supplementary bundle 1 tab 8. Page 164 of the bundle. Mr. Borowski's here dealing with lack of inventive step of non-standard over claim 1. Paragraph 177. He refers to locating items under the seat, as was done in the M-power system. The motivation for doing so would be to provide a safer system by protecting the supply device from damage, as well as protecting passengers from the risk of electric shocks. It would also be easier to replace any broken parts if such units were separate. Mr. Borowski was articulating, by reference to the M-power system as being an example of the general desirability of moving the supply device under the seat to protect, amongst other things, passengers from shock. As for Professor Wheeler, I think it's probably easiest to get the submissions from our closings. So, supplementary bundle tab 2. Tab 18, page 328 of the bundle, and you'll see a heading separating socket and supply, and you'll see from paragraph 143 through to 152 references to the cross-examination of Professor Wheeler in relation to Aring. And, for example, paragraph 150, in the Aring specification, contrary to Professor Wheeler's initial suggestion, the location of the SEB served to improve safety. So what was being done there was I was putting the Aring specification to the witness. I was putting to him that the Aring specification was a document which the skilled person would find. The judge said he didn't have to decide that. And instead he found at paragraph 208 what would be, my paraphrasing, self-evident to the skilled person in any event. So the Aring specification and the benefits as taught, or rather as I put to the professor, of moving the supply device under the seat were put to the witness on that basis. If you then turn in the closings to page 354, and my friend took you to paragraph 288. Alternatively, so this is the obvious. This is the case against claim 1. First of all, with anticipation, and then 288. Alternatively, if the remoteness feature is not disclosed by knowledge-finder, then it would nevertheless be obvious to the skilled person to implement it. That is for substantially the same reasons as those explained in relation to Salati at 253 to 259. And if you look at 253 to 259, they include, at paragraph 256, a reference to the Aring. So we have submissions to the judge as to what would be part of the common general knowledge based on Aring. We have the judge making findings as to what would be self-apparent to the skilled person in any event, having been shown Aring. You have an attack, an obviousness attack, starting with Salati, which includes Aring, and that same matter is relied upon for the purposes of knowledge-found claim 1.
Was it common ground that this Aring specification was common general knowledge?
Sorry?
Was it common ground that this Aring specification was common?
No, it wasn't. No, it wasn't.
Was there a finding that it was common general?
No, the finding at 207.
Why are we looking at it?
Sorry?
Why are we looking at it?
Why are we looking at
common
it?
general knowledge?
No, because the reason we're looking at it is because the judge made findings as what would be self-apparent to the skilled person in any event.
Oh, I see. So not based on Aring.
No.
That's you're saying it's not really about Aring at all. It's about, you say the finding is that something's common general knowledge.
Yes, absolutely right. I've advanced my case to the judge on the basis of Aring. Right. And I've submitted to the judge that what is in Aring would be part of the common general knowledge. Right. The judge hasn't accepted that, but he's found instead, or found in the paragraph that follows, that in any event there are certain propositions which are derivable from Aring, which would be apparent to the skilled person in any event.
And that's in 208.
That's 208 of the judgment. As far as claim 2 is concerned, there was a suggestion by my friend that I hadn't cross-examined Professor Wheeler as to the disclosure of Neunschwander in relation to the timing circuit. That is not correct. The transcript is at SB2 tab 21. Tab 21. And I'm afraid, apologies again, I'm giving you the internal page numbers. Internal page 356, all the way to the end. And your lordships will see that it is a particularly tortuous piece of cross-examination, because Professor Wheeler was not prepared even to accept that he had not considered the disclosure of substantially simultaneous text in Neunschwander. So at the end of the day, we didn't get very far with it. But my lords, I do say that to criticise this appeal on the basis that it is opportunistic, because I'm relying for the purposes of this appeal on findings that were made by the judge in relation to common general knowledge. Such findings happen to be inconsistent with what I was urging him to find in relation to common general knowledge. It is not a fair criticism of the appeal. That is the nature of the appeal. We are looking at the judgment and looking at the findings that were made by the judge and the approach that the judge took. Almost last point, the pleading point. Obviously the starting point on that issue, so we're talking about obviousness of claim 2 and the relevance of the safety advantages achieved by the timing circuit. The judge has found in paragraph 269 that the evidence at the trial was that the timing device contributed to safety. The judge has made that finding. And I think the nature of my learned friend's respondent's notice is, they challenge that. Their challenge is to say, well, actually what the judge should have factored in was the nature of the pleading, which my learned friend has articulated. Now, the fundamental problem with my learned friend's approach to the pleading is this, that he gave you an account, a technical account, of what a ground force interrupter does. Ground fault interrupter. And there was technical evidence at the trial as to what a ground fault interrupter does. And that was evidence that was given by Mr. Borowski in bundle SB3. Page 607. I hope this is behind tab 1. Yes, it is. 607, it comes, this is some re-examination of Mr. Borowski. And could I ask your lordships to take 607 and look at the internal transcript, page 637, starting at line 20, and read to 638, line 12. So my learned friend's account of surges, and a surge being something that was possibly fatal, certainly a problem, have no evidential foundations. And, my lords, the proposition that in those circumstances it would not be useful to have a GFI as an alternative simply to the simultaneous detection of the mitigating evidence, my lord, can't be right. And bear in mind that the pleading for which he makes complaint is not that in moving from the original system to the modified system had no effect on safety, had no material effect on safety. My lords, lastly, claim 3. You have my submissions on that. You have my submission that it does not constitute a withdrawal. It is a late amendment, and your lordships will take that into account, no doubt. But the evidence is in, and you've had very detailed submissions from my own friend as to the merits, or he would say the merits of that matter. If there's anything else I can help you with.
No, thank you very much indeed.
Thank you very much.
Well, Mr. Acton, Mr. Cadogan, thank you both very much, and your respective teams, very impressive teams from this perspective, if I might say so. We'll obviously be reserving our judgments. They will be delivered in draft in due course for typographical errors. And I would hope that once you receive them, you'll be able to agree consequential matters in the order, but if not, short written submissions dealing with any outstanding matters. So unless there's anything else, that concludes this hearing.